Good afternoon. I'm going to go ahead and get things started as people continue to file into the room. My name is Laura Heisler, and I'm Director of Programming for WARF. And you are attending the second in our new series, Entrepreneurons. So thanks so much for coming. If you were here last week, you know that this is sort of a new twist where we're trying to give you a sense of what's going on from a big picture standpoint on a variety of topics important to think about as you think about starting a new venture, and then bring it home to more local perspectives. So each Entrepreneuron session consists of two segments. The first is a presentation, and that presentation today and every time will be followed by a brief Q&A, so you can bring up any immediate questions that are burning on your mind, and then we'll take a quick break and then come back and have a panel of people from a variety of different vantage points on the topic at hand. Today it's on the importance of intellectual property, and you'll have a chance to have those questions broadened out through the panel discussion and through, again, some Q&A. So that's the general approach that we're taking. Just to remind you of what lies ahead yet this semester, these are the sessions coming up. We have another one a week from today. And then, as you can see, through the end of the semester, and we'll be teeing up a similarly deep set of topics in the second semester, and we're in the process right now of pulling all of those talks together and hopefully can announce dates and speakers in the next couple of weeks. So without too much further ado, I'm going to go ahead and introduce today's keynote presenter, Stephanie Adamany. Stephanie is Associate General Counsel for WARF. She's been at WARF for 7 years. Does not seem like 7 years. It's gone really fast. Before joining WARF, Stephanie worked for a law firm in the Twin Cities where her practice focused on patent prosecution and IP litigation. She is trained as a scientist with both a bachelor's and a master's in biology, and then a JD from the University of Wisconsin. So we are pleased to have Stephanie kicking things off by talking about the core of the importance of intellectual property. So I invite you to think about questions. We'll have some Q&A at the end of Stephanie's talk, and then we'll go a little bit further in depth in the second part of the session. So with that, Stephanie, if you would come on up. All right.
Hi, everybody. I see some familiar faces that are nice to see, and I want to thank everybody for taking the time to come here tonight and listen to this presentation. I call it IP Essentials because what I'm going to cover tonight are some of the basic and most commonly thought of forms of IP, and then I'm going to also talk about some housekeeping issues for businesses that have IP or may have IP, and then the types of value that IP can add to your company. So with that, I'm going to kick it off. Intellectual property. So this is kind of the outline for my talk. What is it? How do you get it? How do you protect it? And how does it add value? So when I thought about this as I was putting the presentation together, I thought about what makes a company. Usually you've got your people, the people that start the company, the ideas and the vision that you have, and that's kind of what prompts you to start it typically, and then the types of products and services that you plan to offer. All of those can digest and come out at the bottom with the IP assets that may add value for your company. Your IP, the IP in the previous slide really was the IP that's generally created by your team. Sometimes it's created with others. So perhaps your team is collaborating with another organization or a research institution or a university. Sometimes the IP could be created by others, and then you're making improvements to that IP or actually working to get that IP to marketplace. An example in the work that I do is with WARF, we license a lot of technology to startup companies. So in that case, the IP is created by others, but licensed from us to start a company. Types of intellectual property can include patents. It can include copyrights, trademarks, trade secrets, sometimes called know-how, sometimes designs or even materials. I'm going to start with patents, which are typically the most costly and the most complicated of the IP topics I'm going to talk on today. Generally, what a patent does is it gives you the right to exclude others from making that invention. So a patent in the US is granted by the US PTO, the government, to an inventor or their assignee, giving them a limited term monopoly. And the thought behind this is that the founding fathers actually wanted to encourage disclosure of ideas and thought that was good for the marketplace. So in exchange for disclosing ideas rather than keeping them secret, you get a limited term monopoly on the invention that you come up with. And so to pursue a patent, there's two things that you do. You file the patent application, and that's really the first start. And then you go through what's called the patent prosecution process. And I'll talk about that in a little bit more detail. The patents have, if you follow the news at all or IP news, you can see that patents can have tremendously high value. But as far as protection goes, they can also be the most costly to acquire and to enforce. So U.S. patents give you the right to exclude others in the U.S. from making, from selling, from offering to sell, and from using your invention. What they do not, however, give you is assurance that you have freedom to operate. And I'm going to use a sort of silly example, but I think it illustrates the point here. So if I file for a patent and I say, like, the example that I give is a really simple one, but it's a fork. So a fork with 3 tines, an eating utensil comprised of a 3-tine fork. And then Dave Kettner, former colleague over here, comes up with another invention that is a fork with 3 tines, but it has a spoon on the opposite end. Well, my patent, I have a patent and he has a patent, but he actually can't use his patent because his patented invention requires the use of my patented invention. So that's called freedom to operate. He doesn't have freedom to operate over my invention, although he actually has his own patent too. I know it's a little bit complicated to think about it in that way, but it's a way that inventions are able to build on each other. It also creates opportunities for value that I'll talk about in a little bit. But just something to keep in mind, that as a core principle, just because you have the patent doesn't necessarily mean you're free to do everything that you might think you could do with it. So if you take a look at a patent, once your patent issues, it looks similar to this. You'll get this. This is called the ribbon copy. So once your patent issues, you get a fancy copy from the PTO with a seal on it. The patent is comprised of a few parts. It's comprised of what's called the specification. And that's essentially kind of the story of the patent. It has an introduction. It tells about the state of the art. It tells what the invention is designed to do and the problems that it solves. It tells the best way to make and use the invention. Then there'll be a part that's called the figures, and I just took a picture of a figure that I was able to find. And this is just one example. That's a mechanical invention. If your invention is a chemical compound, you would have a picture of the compound. If it is a vaccine, you could have a DNA sequence. So the figures can be anything, but they're typically figures. And then the heart of the invention in the patent is defined by the claims. So the claims are really unlike anything that you normally read, but if you pick a patent from the internet and start to read the claims, you'll realize that it's a real complicated, generally complicated description for exactly what the invention is. And that is the core of your protection, because that defines the metes and bounds of the invention, and it really sets the boundaries of what you're able to stop other people from doing, what constitutes your right to exclude. So there are a few things that an invention must be in order to be eligible for a patent. The first is novel. It's got to be a new idea. You can't just go get a patent on something that's been out, known to the public for many years. It needs to be also non-obvious, so not an obvious variation of something that's already out and known. It needs to be useful. The example, which I think is kind of a silly one, but it's always the example as something that got rejected for not useful, is a perpetual motion machine, because apparently that has really no useful purpose. And it has to be enabled or adequately described. And this goes back to the bargain that I spoke of regarding the trade-off for the disclosure. So you have to really tell people how to use it and the best way to use it, and that's in exchange for that limited monopoly that you get. It can include many things: processes or methods, machines, articles of manufacture, compositions of matter, chemical compounds, improvements to any of the above. And then there's a couple special categories. There are plant patents and also design patents. Those would be maybe designs to a useful item, like perhaps a new design to a lamp. So when you're thinking about whether or not you should be investing in a patent for your company, a few things to consider. The upfront costs are one. They can be substantial, and I'll talk about those a little bit more, but anywhere from about $10,000 to $50,000 could run you to get a patent through to issuance. Consider the fact that your invention will become public. Patent applications publish, so if it's something that you would rather keep as a trade secret, you probably don't want to pursue a patent on that invention. Another thing to consider, and this is something that you would likely work with an attorney on, is the likelihood that you will get the claims that you desire. So if you are seeking an invention to have a patent for an invention that's in a really crowded space, there could be a lot of other art out there that's going to end up narrowing the scope of your invention. So that would be something that you would want to investigate before you decide to put the investment forth. Consider continuing costs. Once your patent issues, there are continuing costs, patent maintenance for one, and then potential enforcement. And under the New America Invents Act, there are also more opportunities to challenge an issued patent that could end up running up the costs. And then more costs, foreign filings. The US patent really only protects you in the US. Do you need protection in other countries, in Canada, Mexico, the EU? Basically, nearly most of the developed countries have patent systems. And then consider the value. How valuable to your company is the right to exclude others from doing what you're going to do? Consider the right to license or cross-license. So in the case of the forks, perhaps I really just want to sell my fork in for residential cutlery purposes. And there are other people out there that want to manufacture plastic forks. So I could license to them and extract value in that market without impacting my own. IP is a way to increase your asset list. So like other forms of property, that you can add that to your books as an asset, and often has an investor appeal. So if you're seeking investment, usually investors like to see, what does your IP portfolio look like? Is it robust? Can you prevent others from entering your space? Oops. The clicker is the opposite way that I think it would be. So next up, patent filing and life cycle. So the first step, as I mentioned, is you file an application with the USPTO. That's the U.S. Patent and Trademark Office. And at that point, you can mark your products or services or packaging as that you have a patent pending. So when you see that on goods or services, you know that there's something going on in the Patent and Trademark Office, but the patent hasn't issued yet. Right now, a lot of people are filing provisional patent applications because it's become more important to get to the Patent Office first. That's the result of the American Invents Act and some changes in the system, which I'll talk about in a little bit. Typically, a provisional application is abbreviated, sometimes less costly, and doesn't entail the full full package that a regular utility application is. So next up is the non-provisional patent application. That is what we think of when we think of a full utility patent application. And then there's these other two again that I don't want to fail to mention. So once you file your patent application, at the USPTO, it gets assigned to what's called an examiner. And usually that examiner has some experience in the field. So if you file a patent application for a vaccine, your case will probably be assigned and should be assigned to somebody that has experience in the life sciences. And a bit of time will go by, and you'll get then what's called an office action from the USPTO. And it'll be a correspondence from the examiner citing a bunch of art that is similar, and generally it'll tell you why you're not entitled to the claims that you filed. It'll say, all of this stuff makes your invention obvious, your claims can't be allowed as they are, and it might give you some tips about how you can make your claims allowable. And if you're working with an attorney or you're doing this yourself, you'll write back and say, My claims are allowable, and here's why. And perhaps you will amend your claims to address some of the arguments that the examiner made. But there's this back and forth about whether the claim should be allowed, and that's what's called the prosecution process. And it can take a long time, and there can be a lot of back and forth. And every back and forth, if you're working with an attorney and paying by the billable hour in 6-minute increments, it can be costly. So it's something to keep in mind, and it's one of the reasons that patents can be a costly thing to pursue. So once you get past the prosecution phase, you get to issuance. You get a notice of allowance, so that you get a good news bit of correspondence from the patent office saying your claims have been allowed. And those claims that issue define your invention as patented. So that's exactly what defines your right to, or that for that invention is what right you have to exclude others from using it. And the term for that exclusion period, the term for your limited monopoly, is 20 years from the filing date. So after you get that, then the fourth step comes. And I call this maintenance broadly because some of it is technically maintenance and some of it is just things you do to maintain your rights. So fees, there are more fees. 3.5 years, at 7.5 years, and at 11.5 years. And the fees go up. The 11.5 year is the most costly. And I think that's the way the patent office is saying, like, is this patent still really important to you? Do you want to pay to keep these rights? And so on. After the 11.5, then you're pretty good to go for the 20-year term. Marking. So I talked about marking a little bit with the patent pending. Once you have a patent number, then you can mark your packaging, your goods, or your services in a way that makes sense so that you provide others notice of your patent. And that gives you some rights. So if you end up having to enforce your rights, somebody's using it and you want to make sure that you maximize your damages if you are taking them to court, marking is a good thing to do and just kind of part of the good housekeeping process for companies that have patents. And then lastly, challenges in enforcement. So not all patents go through enforcement. Not all patents have challenges. As I mentioned, under the America Invents Act, there are some newer and different ways to challenge patents post-issuance with the USPTO. But there's also the chance that you may have to enforce your patent rights against other people to try to stop them from using your invention. And I'll talk about the costs associated with that, but they can be significant. So housekeeping. If you're a small company and you're thinking, I'm going to have valuable intellectual property that I want to protect with patents, some of the things you should think about are ownership. Who are the inventors? Are they obligated? Is your group small enough that you talk every day and you know what's going on, or not? Are those inventors or people that are working perhaps to come up with patentable inventions that will be valuable to your company, are they obligated to disclose and assign? Is there a contract in place? Does everybody understand what those obligations are? That's important because in the US, each owner has the right to make, use, and sell and license their rights to an invention that they're a named inventor on. So if you don't have everybody's interest captured in one place, you may not have the exclusivity that you're hoping to have. Another thing to be mindful of, and I call this a housekeeping issue because it's just best to kind of keep it on your radar, is the prospect of inadvertent disclosure. So I've mentioned a little bit the America Invents Act. That went into effect last year and changed the system radically from a first to invent system. The first to invent always in the US traditionally has been the person that gets the patent rights. Now it's the first person to file. So before, if I invented something before somebody else, but they beat me to the patent office, I could challenge that, and if I was the first inventor, would be entitled to the patent. Now, for the most part, the first person to the patent office gets the patent. So it's important to consider that when you're thinking about filings. File early. That's why people are filing more provisionals, because they're less costly and they're generally quicker to put together and get on file. But you want to think about preservation of rights and putting things into the public domain, because if that could spark other people's ideas to come up with inventions that you have or maybe just on the precipice of having, you probably don't want to do that. So you want to think about how you get information out there. Are you disseminating information to the public that would be better kept under wraps for a little while, at least until you're able to get an application on file. So I just put up a few ideas about how things can get out there inadvertently: blogs, conversations, offers for sale, papers, publications. There are many ways if you start really thinking about it, but just something to keep in mind. Last but not least, it's not bad to have a confidentiality agreement on hand. At least if you're talking to people about your invention before you get something on file, you can work to preserve the confidentiality. So when I talk about costs, I was looking for just some hard data on what the costs are, and this was the best thing I could come up with. This is a survey that the American Intellectual Property Law Association does every year, and they do it by area. I picked Chicago because this seems to be the most comparable area in terms of costs. So you'll see here a provisional app can be about $5,000. To file an original regular utility application of minimal complexity, they're saying the mean is about $7,500. When they say minimal complexity, I think of like an improved snow shovel, something that's really not technical and doesn't require a lot of time and expertise on the person, on the part of the person drafting the patent. But even for that, as you go through the prosecution and allowance process, you can find yourself at about $10,000. For some of these other ones, the more complex bio or chemical or electrical engineering, they're saying the mean could come to about $18,000. With the patents that we seek at the on behalf of the University of Wisconsin, we see numbers even higher than that. These tend to be really complicated, really high-tech spaces. So it's not uncommon to see a $25,000 or $30,000 cost total. And this doesn't include appeal. So if you end up having to go through some appeal, you can really run the costs up. So I put these up just because I can say that the costs are high, but until you know what the numbers are, you need to essentially judge for yourself in your situation whether you think the costs are high. But relative to other intellectual property registration, this is the highest cost. And then I looked to the same survey just for some numbers that I could put out about enforcement. So if someone's using your patent and you want to stop them, you file a case in federal court, and these are the numbers that the AIPLA report says are the average. So if your market is small, less than $1 million, you could still end up spending $1 million through trial, and it just goes up from there. Oops. Whoa. So the numbers go up from there, greater than 25 million, which when you read about in the New York Times or some of the other Wall Street Journal cases that are going on with patent infringement, there's a lot more than $25 million at stake, and I'm sure those cases cost a lot more than $5 million. So that's patents. Patents are sort of, I would say, the most costly, most complicated IP to pursue. Next up is trademarks. And trademarks, I think, generally people are more familiar because we know trademarks. Trademarks, we see them all the time. The goal of a trademark is to identify the source of goods. And I think this is a little bit of business protection and consumer protection. When I go into the grocery store, if I want to buy a Coke, I grab a Coke, I see the logo, I know what I'm getting. Coke is able to say, people want my product, here's my trademark. It's identifiable to me, and that benefits both of us. Service marks identify the source of services. So I was trying to think of some service marks today. I think of H&R Block and Orkin. I don't know what that says about where my brain is at today, but those are two companies that provide services that I think have pretty recognizable marks. They can be words, designs, colors, even sounds like the NBC chime when you're listening or seeing NBC ads that you hear on television. Trademarks, when you're registering one federally, you elect the classes that it's going to apply to. So Nike probably started out registering the Nike swoosh and saying they chose the class that included tennis shoes. They've probably moved on to a lot of other classes, and you pay by the class, but typically I think people start out or companies like Nike that turn into big conglomerates probably add a lot of classes as they move ahead in their business. So when you're thinking about trademarks in your business, what might you trademark? Your company name is a pretty obvious one. People trademark slogans, product names, or designs and logos. And when you're seeing products, you sometimes see the R or you see the TM. And the difference, what that means is this is a federally registered trademark. And this is somebody that's just claiming their trademark rights under common law. And I'm going to talk a little bit more tonight about federally registered trademarks because that really is the more complicated one. You can put a TM symbol by anything you have. It doesn't necessarily guarantee that you have rights, but at least it's a way to make an effort to preserve some rights. So trademark searching, I thought it would be useful to just go through this. If you go to the USPTO website, that's uspto.gov, there's a lot of really good information about patents and trademarks, a lot of good just questions and answers that are pretty simple. And it's easy if you're starting a company or a product name and you want to do a search to just go to that website and anybody can do a search there. It's really easy. You select trademarks and then there's a part that says search. So I just started at this point and then I clicked on basic word mark search. I decided to search for Coca-Cola because I knew I would get something and I got a lot. I couldn't even fit the list on here. So I just picked on one that was in the list of Coca-Cola items. I picked Coca-Cola Zero. And then you can see here is the information about the classes. So you can look up the class and see what Coca-Cola is planning to do with Coca-Cola Zero. They're planning to do beverages, soft drinks, syrups, and concentrates. And importantly, for them, they've used it in commerce starting about 2005. So to maintain a federally registered trademark, you have to use it in commerce. And you can't just kind of register a bunch of stuff and then sit on your hands and not have them applying to actual goods and services. And here it's live, so that tells you they're maintaining their rights. If you want to use Coca-Cola Zero, that would probably be a really bad idea because they're using it and they'll probably enforce it against you. Was that the last? Whoops. Okay. So federal trademark registration is what I'm going to talk about. It provides certain advantages. It provides notice, actual, and constructive. So just the fact that you have your trademark up there and people can see it gives you some additional rights. So it is not a bad idea to do that. It provides notice of your ownership nationwide. It gives you the potential to enforce in federal court, which may be to your advantage. And it gives you the potential to prevent infringing foreign goods that have your trademark on them from coming into the US. So how do you do it? You can hire an attorney, and sometimes that's a worthwhile endeavor. You can file it yourself online. You could run into problems where your trademark gets rejected for a reason or another, and then you might end up hiring an attorney anyway. I recently had to have a trademark registered and a little bit of searching. It wasn't a really complicated search and it wasn't a very complex situation, and I think it cost about $2,000, including the fees. So compared to filing a patent, it's less costly and generally quicker. To file, you just have to do an completed form and identify the classes that you're interested in, pay the fee, and then have your mark, a symbol, or if you actually have a logo, you can include that. And then if you've already used it in commerce, you include that as well. The cost is relatively inexpensive for the fees. It's only $325 for a single class. And then you have some maintenance costs. The maintenance costs are not particularly high. On the 10th anniversary, they come out to about $500. But if you're using it and you're still in business, probably not that money spent. And this can go on and on. It's not like a patent where it expires. You can, so long as you're using it and paying the maintenance fees, it can go on indefinitely. Next up is copyright. So copyright is really different. The USPTO doesn't manage copyrights. Copyright's more for things like literary, dramatic, musical, and artistic works. Software also is eligible for copyright. But basically, the goal of copyright is to prevent people from copying your authorships. So copyright protection gives the owner the right to exclude others also, but in some different ways. People can't reproduce the art, prepare derivative works, distribute copies, perform the works or display the works. And you, as the copyright holder, however, can license people to do those things. So that's a way that you can extract value from copyrights. I'm not going to go into the fair use doctrine too much, but there is an exception, and that the typical scenario that I would think of is if I'm teaching a class on art and I put a copy of somebody's artwork up on my slide, I can do that. That's fair use. It's for educational purposes. There's a ton of litigation over fair use every year, so it's complicated. It's kind of interesting if you wanted to do some research on that, but I don't have a lot of time to go into it. Copyright protection, interesting because it exists from the moment you create the work. But federal registration, like with trademarks, provides advantages. And to register it is relatively straightforward, and it is among the cheapest that I'm talking about today. To preserve rights, you just provide notifications. So I put up here an example. You add the symbol, the year, the name of the owner. So here is really what you need. I've seen people do this just to be extra cautious, but I don't really think that adds much, but you might see that. Housekeeping for copyrights. If you're a business and copyrights are important to you, again, ownership. Who are the authors? Are they obligated to disclose and give up their ownership rights to you? Are you hiring people to prepare software or other things? You want to make sure you've got those rights locked down. So is there a contract? Is it clear? Are everybody's expectations on the same page? You can see a theme running through here, but it's really messy to deal with ownership issues after the fact and once it becomes a problem. So it's really good to just have these things buttoned down from the beginning. Registration. Online registration is really pretty inexpensive, comparatively $35, and you can go to this website and learn all about copyrights. The last real core intellectual property that I'm going to cover today is trade secrets. So trade secrets can be a real variety of things, and the key is secret. Trade secrets are things that your business gets value from that you keep as a secret and you don't tell people. So different to patents because you're putting the patented information out there, but trade secrets can be processes, formulas, ways of manufacturing things cheaper or better or quicker or more efficiently that other people can't know just from looking at your goods, and from which your business derives economic advantages. And importantly, you're taking efforts to maintain it as secret. Now, this is another thing you sometimes read about in the news, malfeasance and misappropriation, people running off with trade secrets and using them for other businesses or starting their own businesses. But that's not often how trade secrets get leaked out. A lot of time, I think it's accidents. People aren't taking the reasonable efforts that they should be to maintaining them as secret. And the thing about trade secrets is once they're out, they're out. There's no way to really put it back in the bag. You can't enforce a trade secret, right? Because the value of it is that it's secret. So no registration process. Really, the housekeeping matter is just ways to keep it secret. Contracts. Think about how do your contracts with your employees or other people that know the information allow you to keep this important secret. Have clear processes and procedures for managing, because there is a possibility for irreparable harm if it's accidentally out there, not counting the Trade Secrets Act and the things you can do if somebody is really acting poorly and misappropriating trade secrets. So let's say you have some IP. Now, what can you do with it? First of all, it's a company asset. Just like a real property asset, when you're looking to, say, get investment and you're putting together the documents that somebody is going to look at to do a valuation of your company, your intellectual property could be a main one. It could be the biggest one. It can protect your asset or your business from competitors. If you have a patent, you have the right to exclude other people from doing your thing. So if you have a product of manufacture that's covered by patent and your patent is strong and covers the aspects of your invention or your good that's important, you can stop others from using it, and there could be a lot of value in that. With a trademark, if you have a good name brand that people know, there's a lot of value in that. You can also sell it or license it to generate revenue. I gave one example about field limiting license with my silly silverware, with my fork example. But if I'm making metal forks and there's a market for plastic, I can extract value in the form of a royalty or an upfront fee for that granting that license. I could sell it. I could sell my entire patent portfolio for forks and still retain the right to do what I'm doing, which is making metal forks. So there's a lot of ways that you can, it's just like a property right. There are many ways and avenues that you can extract value. Perhaps I need some other rights and I can trade those rights so that we both have freedom to operate, making it a win-win. So when I was thinking of putting this together, if I were starting a company, what would this sort of due diligence, what steps would I be taking to make sure that I was taking the steps that I needed to protect and maintain my intellectual property rights? First one, and this is kind of, obvious, but it's easy to just let this stuff slide in the busy day-to-day activities of a business, but consider maintaining a list of all your company's intellectual property and updating it on a regular basis so you have it all in one place and there's no wondering. Make sure your company has the proper paperwork in place. So think about assignments. If you came up with an invention and then started a company, does your company own it, an invention, or do you? Have you licensed it to them? So think about the paperwork that you need to make sure that you have the rights that you are intending to have. Employment agreements, do they cover IP? Will there be people that are your employees that might be making inventions? Think about work for hire. Think about confidentiality obligations. I think there are a lot of companies that just keep a standard template that's a confidentiality form so that they can use that when the opportunity presents itself and not have to try to scramble to put something together. Think about the internal disclosure process. Are you working closely so everybody knows what's going on, and if inventions happen, everyone will know right when they happen so you can make a decision on it? Or are people working remotely, or do you have collaborators and you're not discussing with them pretty regularly? And should you have procedures or processes so that you get together once in a while and talk about what's new, and then you can think about what you should do about it, whether you should take steps to protect it? So the main point that I thought was processes and procedures. A little bit of understanding of IP and then some good processes and procedures can get you a long way. Knowing the relevant IP landscape defensively. So if you're entering into a space and you have competitors and you know that they have patents, you can go to your attorney and get what's called a freedom to operate opinion. They can look at, or you can look at what sort of patents are out there that might prevent you from doing what you hope to do, and think about that. Better to think about that sooner than later. Just kind of good housekeeping. Also know the IP business landscape offensively. Are people doing things that are sort of morphing into what your product looks like? Do they have things in the marketplace that you think might read on your claims or pending claims? So it's important to keep an eye on that. Are people using slogans or trademarks similar to yours that you think might cause confusion for your customers? Just kind of awareness, processes, and procedures, I think, is the best thing that a business can do if you really want to be maximizing the value for your IP. I don't know, I guess I'm a little bit early time-wise, but if you have any questions specifically for my presentation, I'd be happy to take them now. And we have a great panel that will be able to answer a lot of complicated questions as well. So if you want to save your questions till that, that's fine too. Oh, could you come up and use the mics also, please?
If your company has both service and products, and you're looking at whether you use the service mark or the trademark, I keep getting all different types of answers all over the field on whether you should put for your company an SM after it or a TM until at least when you're starting. What advice would you have on that?
Well, I think the SM and the TM are the common law rights. So
Right.
you see people marking services as SM and then TM as trademark. If you register, if you go with the federal registration, you just use the R. So it makes it a pretty easy answer. If you have different names, I don't know. That might be a good question for if people use both. I don't think I've ever seen something that has an SM and a TM on it.
But if you had to pick one and you're just starting out, TM?
Yeah.
Okay, thank you. That's a starter kit is what I'm looking
Okay.
for. Thank you. Sure.
If you get a freedom to operate opinion from the and then you act on it and you think you're safe and later on you find out you're wrong, do you have any recourse? Did you go back to the law firm and they're liable or?
Well, it puts you in a defensible position. So if somebody sues you, so you get a freedom to operate opinion. Yeah, there's no guarantee. It's likely your freedom to operate opinion will say like, we are reasonably, it's not going to be like, yes, you're definitely in the clear and come to us if you have any problems. It's going to be a little vaguer, so you have to use your judgment and talk through that with your counsel. It does prevent you, it has the potential to prevent you from incurring damages for willful infringement, which are usually can be triple the damages that you would be subject to for regular infringement. So it could still not be a great scenario because you could find yourself being sued for patent infringement, but you've done what you can. You have a case to say, I've done my due diligence and I had reason to believe that my product or service didn't infringe. So there's no super clean answer, but definitely it's worth talking to someone about if you think you're kind of trying to get some guidance on that.
Could you explain or comment on WARF's role, where WARF fits, the scope of the types of work that WARF does? Do patents typically go through WARF only for certain scopes of projects or only for certain faculty, for certain staff? How does that whole system work relative to non-WARF related patents and trademarks, et cetera?
Okay, so WARF is the designated patent and licensing management or organization for the university. The university is really unique in that the university employment agreement doesn't require that faculty and staff assign their IP to the university. Most other universities, all the IP is assigned right away. So at the University of Wisconsin, there's a process where if a faculty member has an invention, it goes through a disclosure process. The university, it comes to WARF. WARF looks at the invention. It also goes to the university, and the university sees whether there are any funding strings attached to that research that basically led to that invention that has IP strings. So if there's federal funding, there are IP strings. If there's sponsored research funding, usually the company is expecting something in the way of IP rights. So yeah. Then it would come to WARF, and WARF will either decide whether to take it on, take assignment, and go through the patenting process or not. Copyrights, maybe Matt can talk a little bit about copyrights and the university, but does that give you... And so then once WARF has the technology, we look for good commercial partners to take that technology to the marketplace through licensing.
Thank you.
Mm-hmm.
Stephanie, I was just curious. You mentioned the new law is regarding first to file over first to invent, and I was wondering if you could comment about some of the other changes that may disadvantage small companies or independents that are filing patents.
Well, the two that really come to mind are the more opportunities for post-issuance challenges. So there's a longer period there's sort of more kicks at the cat once your patent issues. There are more chances for people to make filings with the USPTO to say really you weren't entitled to those claims. So you get your patents, you get that happy letter saying you have a notice of allowance, and then you have a period of uncertainty, and you may end up spending more money, and you may end up not getting the claims that you were just told you get. So that and the first to file, I think, are the biggest challenges for small companies and small inventors, because you don't know quite how it's going to increase the costs. And then first to file, you've got to decide really soon whether it's worthwhile to make the investment. Before you had a little bit more, you could see where it's going, see maybe some more time to really think about it. And I think that's why I know that a lot of law firms are now recommending you just get a provisional on file, because it's less expensive and can be accomplished faster. We're not totally, I guess WARF still is kind of taking a look at that, and generally we try to get everything on file, because if we were going to put the investment in, we want to have a full application with the claims as we see them. But I think that's an area where there's some room for exploration. Big companies, I think, are just filing faster, and also I've heard are keeping an eye out for things like blogs or places where people are talking about what their inventions might be, and then potentially scooping those inventions up, or the patent rights to those inventions. The panel might have some more to add on that. That's my perspective.
It might not be a proper question, but yeah, I'm now working on my invention, and it sounds like that applying for a patent would be very expensive for an individual. Yeah, but I really want to bring my invention to the market. Yeah. Could you provide me some other ways?
Yeah. Well, you don't have to get a patent to bring an invention to market. Patents give you certain rights and abilities, namely the ability to exclude others. But there are some things where patents really aren't the best tool to give protection. Sometimes it is. And then, like, I think the upfront investment can be anywhere from, depending on the technology and how complicated it is, from like 5 to 7, 10,000. So that is a lot of money to come up with right away. I think some firms have ways that they do different ways of billing, so that maybe you're not paying all of the costs right up front. But I think it would be important to do the analysis. What is the value of getting a patent for that particular invention? Is a patent the best way to get to a point where you could commercialize it or make the product available, or are there other ways that don't require that protection? I think, for example, in computer technology, things are changing so fast that 20 years is a long time. The technology is going to be obsolete. So the value is really on the front end for that. So you've really got to just do that calculation and consider the value and the advantages.
Yeah, I really do not want to apply for a patent, because it also waits me for 3 years or 5 years. And I also do not want the company to do that. Mm-hmm. So, yeah.
It's complicated, the question.
Yeah, maybe a stupid question. Yeah.
How much proof do you have to file a patent? Like, if you have an idea and you think it's going to work, but you can't definitively prove it, is that okay?
Well, you have to have what's called either actual or constructive reduction to practice. So you either have to have made sure that it works, or somebody skilled in the art would be able to read your description and be reasonably certain that it will work. So can either fall into one of those two categories, but it can't be just totally speculative.
This might be an unusual question to ask right now, but if you had a patent, a trademark, or a copyright, how would you know if someone is violating it?
How would you know? Well, usually somebody typically has to tip you off. So what we find at WARF is a lot of times the inventors know what's going on out there, or the companies that have licenses. They're monitoring the marketplace. So they will say, hey, we saw this product, or this seems really similar to what our patent is. And then we'll hire an attorney to do an investigation. It can be a little more straightforward with copyright or trademark, because it's a little bit more obvious. Although with trademark, it might be kind of similar and there might be a question, and I would consult an attorney on that. But how do you actually know if there's no like process that you get notified automatically, or your patents to the patent office and the patent office notifies you. So it's really just keeping an eye out in your marketplace and kind of knowing to the extent you can what people are doing.
Thanks. Are there any rules of thumb or guidance you would give an inventor on how to properly talk about their idea prior to having this sort of IP protection?
Oh, that's a tough one. Well, the advice that I think we're giving to inventors is tell us before you file, and we'll try to get something on file. I guess that the confidentiality agreement can be your friend, depending on who you're talking to. If you're talking about a potential business collaboration, I think that's always a good idea to have that in place. Also, perhaps with some use restrictions about, just making clear what you're telling them. A good practice is if you're telling people something in confidence to make sure like you're all on the same page and you know what's being said or handed across the table and it's marked.
If you could summarize the state of the practice for international protection, specifically the BRIC countries, Brazil, Russia, China, India.
Well, that's a tough question, and I am not an expert on that. I think the state of prosecution, so I think India and China are making strides. I know we were just talking to a foreign associate about China this week who lives in China, and he said, China, one of the things you think about is what good are my rights if I can't enforce them? You can file a patent. It's not terribly expensive in China. I think it doesn't take a super long time, but what can you do with it? China's been notoriously bad about enforcement, and he thinks they're getting better, and so there may be maybe that is money well spent these days. I think you've got to consider where is your market going to be, and is it worthwhile to make that investment in those countries. The standard countries that you look at where you can, they have really decent processes and patent offices, and you can reasonably expect to enforce your rights are the EU countries, Canada, I think Mexico, and those are the common countries that we file in, although China and India are big and growing markets. So I think you really have to consider your product line and whether that's a decent investment for you. I don't know off the top of my head. I can't say it's $10K to go through Russian prosecution or $5K to go through Chinese prosecution, but you can probably find information about that as an average on the internet or talk to your attorney.
We're going to take one more question now, and then we're going to take a quick break and then come back for more discussion for the panel. So this last question now.
If somebody is not part of this institution or an alumni and they have an idea, but they want to work with WARF or the university, how do they go about that?
Well, WARF has a nonprofit organization that has a charter that limits us to really performing IP functions for the university. I think that we've occasionally taken alum inventions to patent and try to move forward in the marketplace, but WARF itself doesn't offer resources, and I'm trying to think if I can think of any places that do. Do you know? I can think about that and then tap you afterwards if I come up with something.
Well, thank you so much, Stephanie, for a terrific talk. Everybody please join me in thanking Stephanie.